A very good evening, ladies and gentlemen. Welcome to the Jurists Forum 2025 pre-conference session number 2. Thank you all of you joining with us today. The topic of today's session is Evolving Jurisprudence on Right-Based Judicial Review in Sri Lankan Administrative Law. This is an important area in law, especially when we talk about protecting people's rights and how decisions are made by the government. We are very happy to have Dr. Thaksala Udanyanganie with us today as our speaker. Dr. Udanyanganie is a senior lecturer at the Faculty of Law, University of Colombo. She teaches constitutional law and administrative law at the undergraduate level. She also coordinates the one-year LL.M program. She teaches several postgraduate subjects such as judicial review, administrative law, and research methodology. She also teaches human rights related program at the Center for the Study of Human Rights and the Faculty of Graduate Studies. She also worked as the Quality Assurance Coordinator of Faculty of Law. With her experience and knowledge, we believe today's session will be very valuable for all of us. After the main session, we will have the Q&A session where you will get the chance to ask questions from our speaker. So please stay with us till the end. Now it's my pleasure to invite Dr. Udanyanganie to begin the session. Madam, the floor is yours.
Thank you. Thank you, Sweta. Can you please make me as a host or co-host?
Yes. Okay, ma'am. Ma'am, you are already a co-host.
Thank you. Okay, very good evening to you all. I'm sorry, I just finished my postgraduate session. So earlier also I received one of the invitation from your society, but I could not be able to attend. Today I thought anyhow I should participate for this discussion. So anyway, the Sweta mentioned please keep your Q&A the questions at the end. But anyway, I think how many members here? Yes, 50. So anyway, if you seriously want to clarify something, even in between, you can ask. But if we are realizing it's a kind of like the difficult, so then they will keep the question at the end. So here, I don't know the background of yours, but I believe many of you are law undergraduates representing various levels. It means some of you may be in first year, second year, third year, etc. When it comes to our faculty under the new syllabus, we are teaching administrative law in second years. But some of the universities I know, they are having administrative law during their third year, etc. Probably second and third years. So my topic, I asked from Tamoji, what's the purpose of having this webinar? Because it has mentioned pre-conference webinar series. Then I thought it is necessary to direct certain areas for your research, etc. But she said, no, this is entirely for the knowledge purpose. Anyway, this is a subtopic or the sub area that we can discuss under the administrative law, basically when it comes to judicial review. So in broader context, judicial review, we can identify under 3 categories. The first one, judicial review of legislation. The judicial review of legislation, basically you are learning under your constitutional law, judicial review of fundamental rights, and judicial review of administrative law. First, I want to explain these 3 are 3 different aspects. So don't the mix or misunderstand these 3, or don't try to mix these 3, because we are discussing judicial review of legislation under the different framework. and also the judicial review of fundamental rights under the different framework and the different jurisdiction, and judicial review of administrative law under the different framework. When it comes to the Sri Lankan context, with regard to fundamental rights and also the administrative law, we can identify two different forums. For example, the Article 126 of the Constitution and also Article 140 of the Constitution. But here, why I selected this area, we can identify a very unique development or the unique contribution under the Sri Lankan law. It means at the end, I will explain. Even though we are discussing administrative law principles, especially under Sri Lankan context, we can see some of the fundamental rights. Basically, Article 12.1 has used to interpret administrative law principles. So I will explain what are the instances and examples when we are dealing with the session in future. As I have mentioned, we can identify two approaches to judicial review of administrative actions. So now my entire session will be focused on only about the judicial review of administrative action. So forget about judicial review of legislation and also the fundamental rights. Here we are discussing fundamental rights, but not relating to the fundamental right cases, but with regard to the mostly with regard to the writ cases. So these are the two approaches. Virus-based approach, it means the virus-based approach mainly depending on the grounds of ultra-virus. It is considering as a central principle of administrative law. The other one, right-based approach. So here I'm starting my discussion with a broader perspective, not rights as a ground, but the right-based review as an approach. So it means basically we can include several grounds under the right-based judicial review. When it comes to ultra-virus-based approach, basically, I think many of you are aware, under the ultra-virus doctrine, what we are looking at, whether that particular decision taken by the administrative authority or the officer is within the scope of the power under which they were made. It means you all aware administrative power derives from a particular statute or the legislation. So the rationale behind this ultra-virus doctrine is the administrative authorities and administrative officers, they should take their decisions within the scope of the statutory limitations, so that within the four corners of the legislation. So if decisions are made outside or without power, the court can hold them to be ultra-virus. Thus, what's the outcome? Those decisions are illegal. So please keep this word in your mind. These decisions are illegal. Here what we are mainly looking at, only the legality or the illegality of a decision. When it comes to right-based approach, this right-based approach actually developed gradually, especially in UK context after enacting Human Rights Act in 1998, and also with the development of subsequent grounds of judicial review. I will explain you. And in Sri Lankan context, of course, after the introduction of the 1978 Constitution. So very recently, we can identify the very progressive the judicial decisions with regard to this. But we are mainly the reviewing under the right-based approach. Here, the judicial review is based on good administration and rule of law. I think you are having at least a basic understanding about the constitutional foundation of administrative law. It means what's the relationship with the Constitution, because some of the grounds that we are considering under the judicial review, those are basically stems or derived from sovereignty of parliament, and some other grounds developed through the rule of law principle. So these two constitutional principles are highly related in the context of administrative law. Here, the right-based approach, this is very much related to the concept of rule of law, not the sovereignty of parliament. So if you are considering the ultra-virus-based approach, as we discussed, the rationale behind the doctrine of ultra-virus, it means the administrative authorities or the public authorities, they have to take decisions within the scope of the legislation. It means they are giving effect to the intention of the parliament. You know, under the sovereignty of parliament, what is the meaning? Parliament is the supreme authority, not the law. Parliament is the supreme authority. But when it comes to right-based approach here, they are mainly look at individual rights and the principles of good administration. So it's very much relating to the doctrine of or the principle of rule of law. It led to shift judicial review from mere virus-based to more intensive, merit-based, right-conscious review. So why I have mentioned here, the intensity of review is very, that higher than the ultra-virus-based approach. In the context of ultra-virus approach, they are only looking at the legality or the illegality. So they don't want to look at whether that particular decision is right or wrong. Sometimes there may be right decisions, but it's illegal. There may be wrong decisions, but it's legal. So that difference or then that intensity cannot address within the doctrine of ultra-virus. So that is why timely this right-based approach evolved through several grounds of judicial review. So first, I would like to explain the theoretical basis. So if you cannot understand at the end, let me know. Theoretical basis means I have told you there are two basic constitutional principles, sovereignty of parliament and rule of law. This right-based review is more aligned with the principle of rule of law. Even under the rule of law, there are two different concepts. It means the formal conception of rule of law and the substantive conception of rule of law. I think these two words are a little bit new or difficult to understand for you, but you know the meaning. Formal conception means how laws are made or how laws are enacted. What is the process of enacting these laws and how these laws are applying. So here they are not looking at the content or the context of laws. It means what's the procedure enacted these laws. But under the substantive conception, they are mainly looking at the justice or the fundamental rights or the moral values embedded in laws. Basically, what is the content of laws? Not the procedure, but the content of laws. So here, the right aspect or the right-based review is more aligned with the substantive conception of the rule of law. Are you all clear up to this? The theoretical basis that we can identify as a substantive conception of rule of law. So this substantive conception or the right conception of rule of law, the first discussed by Ronald Dawkins. He is one of the greatest scholar and he contributed a lot to develop this right-based jurisprudence. So what is our fiction or the debate here? Because still, it's true that even in UK and even in Sri Lanka, we are using this right-based review a lot. And then both countries have series of cases decided. Even very recently also, many cases were decided based on this. But still there is a debate or there is the contradiction with regard to this. What is this contradiction? Is right-based review justified? Do we need to have a right-based review? Why? Because basically this debate has arisen due to this the certain theoretical confusions. Many constitutions, including Sri Lanka, our constitution already embedded the principle of separation of powers. So, under the separation of powers, legislature has assigned to make legislation, and then the judiciary has assigned to review those legislative enactments or laws. But under this right conception, there is a risk that the judiciary is overstepping their limit. Judiciary is overstepping their limit, and judiciary is trying to look at the merits of the decision, not only the legality, like under the ultra-vires doctrine. So it means that the interference of the judiciary is very high. So some of the scholars, they are not, that they don't like this. And then they are arguing that it means the judiciary is trying to overreach their powers. And over-activism of the judiciary is also not good. Then it is badly affect the very basis of the constitutional separation of powers. So that is why there is a counter-argument against the right-based review. What is this argument? Can the unelected judges highly interfere with regard to the legislative decisions and to give or to engage with merit-based judicial review? So we'll try to identify the proper answer to this. Still, this is debatable. So if you are thinking about certain research areas for your conference, so you can think about what should be the limitation of the court. So what should be the role of the judiciary in this regard? So then, say for example, if the legislature and the executive is not properly functioning, or if these two institutions are not functioning in favor of or the best interest of the citizens, then what is the responsibility of the judiciary? Can the judiciary disregard rights very simply? Or is it necessary to undertake the role of protecting individual rights? So in the Sri Lankan context, you can clearly identify and practically experience this during this Aragalaya period. So that's why I told you, still this is, that this is a gray area. Even though the right-based review justified and established, there are criticisms and counter-arguments as well. So these are some of my answers to the question. Is right-based review justified? So you may have different answers. So that's why you can initiate a fresh research based on this. So there has been a change in what the notion of democracy entails. That's true. According to democratic principles, our representatives are representing ourselves. So we have already delegated our sovereign powers to them. Our constitution, it has clearly mentioned the people's sovereignty. So there is an assumption the legislature or the representatives, they are representing our sovereign powers. But this definition of democracy also now changed a lot. So we need to think about this changing notion of democracy when we are interpreting the right-based judicial review. The second one, the ultra-vires doctrine fails on a historical appraisal to establish that it was indeed the foundation of the judicial review. Earlier, it was correct, because the ultra-vires doctrine also covers both procedural and substantive aspect. I think you are aware, substantive ultra-vires and the procedural ultra-vires. But later on, with the development of human rights and also the changing nature of the state welfareism, etc., the applicability of the doctrine has changed a lot. Later on, they produced or they submitted the modified doctrine of ultra-vires, but even the modified doctrine of ultra-vires was inadequate to address all these issues. So earlier, this ultra-vires doctrine was considered as the central principle of administrative law. Now it is not the case. Many new grounds were developed, such as legitimate expectation, the proportionality, Wensbury unreasonableness. Even under the Wensbury unreasonableness, different levels of test were developed. So therefore, in the present context, the doctrine of ultra-vires is not enough. It was one of the reasons to improve or develop right-based judicial review. The other one, the ultra-vires doctrine fails to attract legitimacy. So do you know the meaning of the word legitimacy? Earlier, I used the word legality. Ultra-vires doctrine, of course, reviewed the legality of the decision. Did you remember? But this doctrine fails to attract the legitimacy of the decision. Legality only looked at whether that particular decision is within the purview or the parameters of the particular legislative enactment or not. But when it comes to legitimacy, it is going beyond the legality, and it should consider the correctness of the decision as well, right or wrong. So in modern times, even if a majoritarian view of democracy is adopted, this ultra-vires doctrine fails to attract this legitimacy. The other reason, it provides the objective criteria. It means the right-based review. Right-based review provides the objective criteria by which judges could evaluate the lawfulness of the exercise of official discretion instead of having recourse to their own subjective preferences. For example, if you are taking the proportionality as a ground, the test of proportionality provide or the produce 4-step structure. So it's a kind of like formula. You can easily put that decision into the formula and get the correct answer. There's no the larger discretion to the judiciary to decide the legality or illegality or the rightness of the decision. But when it comes to these other grounds, such as then the initial status of Wensbury, like that, judges are having a huge discretion to decide the final outcome. So based on these reasons, actually, right-based review can be justified. Hope you are clear up to this. So further, we can strengthen this argument by explaining the subsequent developments of the other grounds of judicial review. As I have mentioned, not only many grounds of judicial review, even the locus standi have expanded and attempted to include rights aspect. So if you are looking at the Sri Lankan context, you can identify the well-established public interest litigation. Now, there are many cases you can identify. It's highly useful. It means the locus standi have also expanded and relaxed the relevant rules. In addition to that, unreasonableness, proportionality, substantive legitimate expectation, public trust doctrine. I didn't mention here about the public trust doctrine. So those grounds were developed and well established within our system now. I'm specifically referring to the Sri Lankan system, because now we are having our own and the unique administrative law framework. So all the times we don't need to look at the comparative aspects of U.K. So I believe the Sri Lankan administrative law principles are more developed and far ahead than U.K. principles, because our constitution now already included this into the constitution. So if I am briefly discussing about the UK situation, because up to 1978, we also followed and we also consider common law decisions or the cases decided under the English law. Why? Because under 1947 Constitution and also even under the 1972 Constitution, this writ jurisdiction was not constitutionalized then. We also relied upon the English law principles. But in 1998, in UK, Human Rights Act was enacted. After enacting this Human Rights Act, legitimate expectation, proportionality, these grounds were utilized in the context of the Human Rights Act. It means like these grounds the expressly recognized by this Human Rights Act. In Section 6 of the Human Rights Act, it has clearly mentioned, it is unlawful for a public authority to act in a way in which incompatible with the convention right. Which convention right? European Convention of Human Rights. So therefore, after 1998, UK, the courts, especially with regard to right issues, they attempted to align with the Human Rights Act. In our case, we initiated this right-based review or the development of it after enacting 1978 Constitution. On the one hand, under the Article 126, fundamental right jurisdiction was given to the Supreme Court. Chapter 3 incorporated as a fundamental rights chapter. And again, under Article 140, writ jurisdiction was given to the Court of Appeal. So therefore, now we are having a constitutionalized administrative remedies. Our administrative remedies are also constitutionally recognized. So it's a difference between UK and the English law and the Sri Lankan law. Just I have mentioned only one case to reflect upon the Human Rights Act. This was decided in 2007. This Begum versus Denbigh High School case. What happened in this case? The earlier that girl, as far as I remember, Shapna Begum, she used to wear this jilbab, but it was not the uniform policy of her new school, Denbigh High School. So what was the issue here? Did the school refusal to allow Shabina Begum to wear this jilbab, and it breached her rights under the Article 9 of the ECHR. So here, the majority decision, the majority represented the Lord Bingham, Lord Hoffman, etc. They decided that there was no interference with her Article 9 right, because she had chosen to attend a school that had non-uniform policy, and she could have attended another school that permitted the jilbab. Even if there had been interference, the school's decision was proportionate and justified. Under the Article 9, subsection 2, it pursued a legitimate aim and struck a fair balance. They used proportionality test. So if we are moving towards the Sri Lankan developments, so if you are further thinking and if you are having an idea to further research, of course, these 4 aspects you can separately consider. So I don't have a time to discuss all these issues in detail. So therefore, I'm only discussing selected cases and certain selected issues. But this development we can clearly see within the Sri Lankan context. The use of administrative law concepts to define constitutional rights. So I mean that the blend or the merge this administrative law concepts and fundamental rights. The administrative law concepts or the administrative law principles used to define constitutional rights, and also the reliance on constitutional provisions to expand the ambit of the writ jurisdiction. On the other hand, the constitutional provisions or the constitutional rights were used to expand the ambit of the writ jurisdiction. The other one, increasing use of international norms and the application of judicial review standards to political parties. So international norms were also used, very few cases, but that pattern or that trend already initiated. The development have been accompanied by a relaxation in the rules of standing and the permitting of a larger category of persons to bring claims before court. The other development that we can identify, the relaxation of the rules of standing. If you are looking at Article 126, it has certain strict limitations if you are looking at the literal interpretation. But now, many of these requirements are broadly interpreted by the judiciary. For example, 1 month rule, and then the phrase that particular person or the lawyer should bring an action. Even the phrase executive and administrative authorities. So in this entire provision interpreted in a broader context. So similarly, we can see the same development in the context of Article 140 as well. Article 140 has also mentioned certain very important phrases such as according to law and align with the Constitution, in the nature of writs, etc. So all these phrases were broadly interpreted by the courts. So now, if I'm summarizing what we have discussed so far, how these development were happen. How these development were happen. That's true, the constitutional provisions were there, but mainly these development brought by the judiciary through the judicial interpretation. So that is called like incremental interpretation approach of the court. Gradually, the court attempted to broadly interpret these phrases or the provisions relating to rights in the Constitution. Hope you all are clear up to this. So far we have discussed the right-based approach of the judicial review, especially in the context of administrative action. I'm not preferring the judicial review under the fundamental rights. But the one provision I have to refer because it is highly relating to the writ jurisdiction. So now I would like to change my direction towards rights as an independent ground of review. So when it comes to right-based approach, it includes several other grounds also. For example, as we discussed, legitimate expectation, the proportionality, and the public trust doctrine, unreasonableness, etc. So here, I'm trying to explain you one of the very important improvement or the development brought by our own judiciary. Actually, this can be identified as a unique development of the Sri Lankan judiciary, and through this broader interpretation, Article 12 has emerged as an independent ground of review. Why I am claiming this? Now we can see the continuous application and also the series of decided cases based on Article 12.1. It has become a kind of like the practice or very frequent tradition to look at Article 12.1 and its applicability. So that much you can see and identify. The writ cases are using Article 12.1 with regard to this the judicial review of administrative action. This was initiated during this period. Here I have mentioned Professor Daya Idirisinghe case. It was decided in 1995. What happened here? The court had to consider an application for mandamus by a student of fine arts. This was happened in Kelaniya University. Courts clearly mentioned that Article 12 of the Constitution read together with the rules and examination criteria of the University of Kelaniya gave a duly qualified candidate a right to a degree. Say, for example, that particular student already completed all the requirement of examination according to bylaws, and also the relevant regulations, fulfill relevant regulations under the examination rules. Then the university has a duty to grant the degree. That a student has a right to obtain a degree. Look at the next part. The university had the duty to award the degree without discrimination, and even where the university had reserved some discretion, such discretion should be exercised without discrimination so as not to violate Article 12. Even though the university is having a discretion, I think you know the difference between duty and the discretion. If there is a duty, you have to mandatorily or compulsorily fulfill that particular obligation. But if you are having a discretion, then you may have certain alternative decisions. So the best option, the best decision you have to take. So here what the court mentioned, even though the university is having a discretion, that discretion should be exercised without discrimination and align with the Article 2. So although the application was for a writ under the Article 140 of the Constitution, this was a writ application. The court held that the university's discretion must be exercised in conformity with the Article 12. That is where you can see these two jurisdictions are combining, merging or blending. This was a writ case, but in this writ case, the court considered the applicability of Article 12. There are certain other cases. This is another case, Karunadasa versus Unique Gemstones. In 1997, this case was decided. Here also, writ application. Supreme Court held that Article 12. I will tell you why this goes to the Supreme Court, because generally written jurisdiction lies with the Court of Appeal. This was an appeal. So then Article 12 supported the view that natural justice required the provision of reasons by public administrations. If the public authority or the public officers, if they are taking a decision, so the reason should be given. This giving of reasons was an important protection offered by the law and facilitated the subsequent review of the decision. Article 12 made it even more compelling that a person be told the reasons for an adverse decision. So here also it was decided that Article 12 need to be considered. This is a very famous case. I think you all are aware, and this is considering as a landmark decision. Hida Teres Mandi case. In this case, we can clearly identify this blending rights with writs. Initially, this case was referred to the Court of Appeal. The Court of Appeal decided that the interest of the group of individuals affected by the project, this is relating to the initial phase of the Southern Highway case, these victims' lands were acquired, but without giving a proper compensation. So that is why this Hida Teres Mandi and others, they filed this case. So what happened? The project should give way to the large social interest of the project. The court should be cautious in using the writ jurisdiction to interfere with the project of public importance that had already commenced, and where the crushing of such project would lead to unbudgeted expenditure. So the Court of Appeal looked at the public interest. because this is a mega development project, and this project, ultimate objective of the project is to bring the development, the benefit for the larger community. So then the Court of Appeal considered the project cannot be quashed, or then the project cannot be cancelled, because then if the court is doing that, then it would lead to unbudgeted expenditure. However, this was appealed to the Supreme Court. The Supreme Court decided executive power was subject to the fundamental rights in general, but more specifically to the limitations contained in Article 12(1) of the Constitution, which guaranteed the right to equality before the law and equal protection of the law. So the Supreme Court decided equal protection of the law included right to notice and the right to be heard. So these two are also part of the natural justice process. Therefore, these victims should give a proper notice, and also they should have an opportunity to provide their reasons before taking a decision. So this is the very clear and the first the case with clear explanation. We can identify this blending writs and rights. Subsequently, you can identify the many cases relating to the public trust doctrine, because in between period, or in the middle period from 1997 or 2000 to 2007, like that, again, very few cases were decided. But with these three cases, the continuous application of Article 12(1) and also the public trust doctrine, we can identify and also well establish. I hope you all are aware about these three cases. Sri Lanka in the Insurance Corporation Limited case, LMSL case. These two cases were involving with privatization, privatization of the state-owned institutions. And the water sage case, again, it was, what was the issue here? Initially they obtained this land for the public purpose, but then later on, they built a private hotel. Under these three cases, it was decided that the court, mainly the court attempted to relate Article 12(1) with the public trust doctrine, because the public trust doctrine ascertained the idea that national resources and also the natural resources should consider as the trust held by the government for the benefit of the general public. You know the purpose of establishing a trust. Here, the government is a trustee of these national and natural resources. So they have to make sure the public interest or the benefits for the general public. So all these three cases, the judiciary attempted to relate public trust doctrine and Article 12(1), right to equality before the law. Not only that, Article 3 and 4, sovereignty of people. So this is also a part of the sovereignty of people. Government cannot take the decisions as they own. They have to consider the people's sovereignty. And they are holding this resources as a trust. That's the meaning of the public trust doctrine. So here, court used a substantive right-based approach holding that violation of public trust amounts to violation of the people's sovereign rights. Look at the broad nature of the interpretation. This is called judicial activism. So therefore, this is a kind of like violation of the rights of the people that should subject to the fundamental rights review. In this regard, we have to look at this article 126.3. I told you I'm not discussing about the fundamental right jurisdiction, but I will refer one particular provision or one particular section, the article. This is relating to the writ jurisdiction as well. Basically, writ jurisdiction lies with the article 140. Why this is important? How many of you have already read this article 126? I know you are well aware about article 126 too. Why this is important? If you are carefully reading this, within this article, we can identify and find the reason for blending writs and rights. So, if there is a fundamental right violation, then later on that application proceed to the Supreme Court, and it is proceeding as a fundamental right application. But it should proceed as a writ application. In this article, it's clearly mentioned, where in the course of hearing in the Court of Appeal into an application for orders in the nature of writ of habeas corpus, certiorari, prohibition, procedendo, mandamus, or quo warranto, it appears to such court that there is prima facie evidence of an infringement or imminent infringement of a provision of a Chapter 3. It meets a fundamental right, or Chapter 4 by a party to such application, such court shall forthwith refer such matter for determination by the Supreme Court. In a writ case or the writ application, prima facie, if there is a fundamental right violation, then that matter or that application should refer to the, or can refer to the Supreme Court. Shall refer to the Supreme Court. Because the fundamental right jurisdiction assigned to the Supreme Court. So that is why if there is a fundamental right violation in a writ application, that particular application generally referring to the Supreme Court. So please read this case. This is very interesting case decided in 2020 because my theme, the recent or the evolving jurisprudence of right-based review. So this is one of the very good example. I'm not discussing all the cases, but very few selected cases I'll be discussing. The Kumara versus Gunatilaka. I think you all are aware about this case because there is a huge discussion about the case those days. What happened in this case? The petitioner had been convicted for murder and sentenced to life imprisonment by court-martial under the Air Force Act. One of the main arguments of the petitioner was that no reasons were provided by the members of the court-martial for their decision. The court-martial was convicted this person, but no reasons were provided. The Court of Appeal was empathetic that reason should have been provided for the decision, and that this failure meant that certiorari would be issued to quash the decision. Reasons were part of the rule of law, a basic requirement of natural justice and inherent in the justice system of any civilized society. It was mentioned in the case. Again, the court referred both Article 12.1 and Article 13.4 of the Constitution to support its decision. And this is the other case. It was also decided in 2019, Aryaratna versus Inspector General of Police. This case also used this Article 12(1) of the Constitution. It has mentioned arbitrary frustration of a petitioner's legitimate expectation in deciding if there had been a violation of Article 12 of the Constitution. So you can see the public trust doctrine related cases. Those cases were also used Article 12(1), and then legitimate expectation related cases. Those cases were also used Article 12(1). And this is also a very famous case, Chunnakam case. It was decided the Sri Lankan citizens or the public, they have a fundamental right to be free from unlawful, arbitrary or unreasonable executive or administrative acts or omissions which cause or the permit the causing of pollution or degradation of the environment. So in this case, I think many of you have read this case. At the end, the court recommended that the compensation also need to be given to the affected parties. So this statement I quoted from this Chunnakam case. So look at the interpretation, how the judiciary attempted to provide a broader interpretation to the Article 12(1). It has mentioned the Constitution does not recognize the specific environmental rights. That's true. Our fundamental rights chapter only included civil and political rights. This chapter does not include any economic, social, or cultural rights, including right to environment. However, has not stopped the Supreme Court from recognizing the responsibility of the state to protect the environment. That's true, the Constitution does not recognize the specific right, but it doesn't mean that the Supreme Court is preventing or stop from recognizing the responsibility of the state to protect the environment. In several cases, the court has interpreted the right to equality, the freedom of engage in lawful means of employment, if you are reading Bulankulama case, and the right to freedom of movement, Article 14(1)(h), to include environmental rights. Directly you cannot, but indirectly through broader interpretation, this right to environment also can be incorporated. In several of these cases, the court referred to the obligation cast on the state in the Constitution to protect, preserve, and improve the environment for the benefit of the community. It does not mention under the Fundamental Rights chapter, but under the directive policies of the state. So try to understand how the judiciary provided the broader interpretation for the recognition of the right to environment, affiliating with or aligning with Article 12(1). We don't have a specific right to the environment, but the judiciary used Article 12(1) as a common right. This instance also. So this is one of the very good area, again, that you can see the various the definitions or the different definitions, different approaches or the different scopes given to the Article 12(1) by the judiciary. So this is also a very recent case. Do you know about this economic crisis case? This is the long name of the case, Atula Siri Samarakon and others versus Ranil Wickramasinghe and others. You must read this case. Again, in this case also, the judiciary attempted to discuss or explore the relationship with public trust doctrine and Article 12(1). Both principles were, or the both doctrines were referred in this case. So what happened in this case? I hope all of you are aware about this case. One of the former president, former prime minister, and former finance minister, former governors of the Central Bank of Sri Lanka, former secretary to the Treasury, and former monetary board, and former secretary to the president were among 13 respondents were declared to have violated, because all of them are public officers. They are taking decisions on behalf of the public. If the public is affecting because of their decision, if the public, they are adversely affecting, then it means they breach their trust. They violated the doctrine of public trust. Because they are taking decisions, those decisions are very much related to the public. That's what this case clearly mentioned. And these respondents were violated public trust and breach Article 12 of the Constitution in their administration of the economy, leading to the economic crisis in the country. So look at these following factors. These all these factors clearly mentioned in the case. So what are those factors? The reduction in government revenue caused by the illegal and arbitrary tax breaks granted in 2019. Can they change the tax policy according to their wish? What happened? Entire country was affected. Entire country or the entire general public adversely affected. The other one, failure to reverse the illegal tax break. It was not reversed. Failure to take remedial measures subsequent to rating downgrades. They went for the IMF, but very late. Failure to devalue the Sri Lankan rupee in timely, orderly, and appropriate manner, despite widespread calls to do so. So the government officers, they have to take timely decisions, necessary decisions at necessary times. That's why they have given administrative discretion. If they are not properly using that power, they are amounted to breach or violate the public trust. And then the decision to continue servicing sovereign debt without any restructuring, the refusal to seek the assistance of IMF until the crisis had exacerbated. You have to read this case. All these factors were clearly listed, even with their names. So why? These decisions are directly affecting to the general public. Their rights are violated. So then the judiciary can interfere to review it on the basis of the right-based judicial review. So did you understand? Before we are moving to final part, because my final question, then in this context, what role assigned to the judiciary? Or else what should be the role of the judiciary in this regard? Because judicial overreaching or the over-judicial activism also cannot be accepted. There are many criticisms, and it will badly affect the structure of the separation of powers as well. So here we need to find a balanced approach. We have to protect individual rights, and also, on the other hand, smooth functioning of the administration also. So what is your answer, or what do you think? What do you think? What should be the role of the court in this regard? Any idea? No idea. I think many students, you are learning administrative law. So just I'm asking your own view. There's no right or wrong answer. Or before I'm moving to my last part, then if you have any question or if you need further clarification, you can ask. Any question or any further clarification?
Madam, I have a question. Can I ask?
Yes, please proceed.
I mean, we know that prescription is always, applicable in law. Then is the judicial review is subject to the prescription? That's my.
You mean that the jurisdiction?
Yeah, whatever under the judicial.
Yes. The Dhammika, it's a very good question. Anyway, I think it's clearly mentioned, even the limit is also clearly mentioned under the fundamental right jurisdiction. But in the writ jurisdiction, yes, because you need to take prompt action, but it's the very flexibly interpreted. It means that generally within 1 year period of time, you can take action. That's the time limit. But even itself, say for example, during that period, if you are not in a position to come to the court, or if you can bring a valid reason, then the court will consider this. But unnecessary delay will not be considered. Reasonable delay is considering, it is depending on the circumstantial evidence, but unnecessary delay will not be accepting by the court. Are you clear?
Yes, madam. Okay. Thank you very much.
It is considering as one of the criteria under not issuing writs. Because writs are considering as discretionary remedies. If there is an unnecessary delay, court will not issue a writ. Let's see one comment. I have to discuss the two factors. Before that, I would like to provide the answers to your question. And I also ask one of the question from you. What should be the role of the judiciary?
Madam,
any other? Yes, please.
Madam, it is to facilitate that to facilitate the process of functions that with the intention of achieving justice.
So you mean that it should be the role of the court?
Yes, ultimately.
Yes.
Justice prevail.
So what kind of approach that you are suggesting? Because as you correctly pointed out, what is our ultimate aim or the objective? Achieving the justice. So therefore, for the sake of separation of powers, or for the sake of majoritarian point of view, we cannot disregard individual rights. So we have to clearly demarcate the boundaries. It is still having as a gray area, because anyway, it is depending on the interpretation providing by the courts time to time. But theoretically, this is one of the lacking area. But the other jurisdictions, or say for example, then the Australia, UK, so they are coming up with certain new conceptions. So I will tell you, you can consider this as your future research areas under this That's why I asked from you, before we are moving to that, if you have any question, I can provide the answers or clarifications. Any question or clarification with regard to the session?
Excuse me, madam.
Yes.
Madam, this Dr. Atul Sri Samarakon case, so once the judgment is given, so what would be the outcome? Is there any way of executing the order to feel the public? What is the benefit that the public will get after this decision of this
Yes.
nature?
Very good question. Very good question. Because unfortunately, this question there's no outcome, because then they the petitioners, they didn't request any remedy. They just challenge these decisions taken by the respective authorities, but they didn't request a remedy. So it was highly discussed during that time. Unfortunately, therefore, can't do anything based on this case. But of course, then further investigation or further action can be taken, and based on that, the proper remedy can be imposed. Unfortunately, based on this case, not, because it was not requested by the petitioners. Judiciary is not giving something like not requested. If the petitioners, if they are requesting, then the judiciary will give. Very good question.
Madam, is it possible some other party to raise the question,
Yes,
case
of
again
course.
and
Yes.
make a request to implement this execution part of it?
Yes, can. Or the group of people, they can file a separate action. Any question? Yes, I can share this PowerPoint presentation with you. So anyway, nowadays, the law students are not asking questions. So you have to challenge, and then you also should come with the preparation. No questions. So then then I will move into my last part. I ask one question from you. So since you are not answering, yes, one has mentioned right-based approach is more efficient than ultra-virus approaches. That's true. But even we should think about what's the better way, or what is the best approach of implementing the right-based approach. So now these two new concepts were emerged very recently. The responsive judicial review and also the dialogic model of judicial review. So if you can further research on this. This responsive judicial review, it was first discussed by Rosalind Dixon in 2022. The responsive judicial review refers to a form of judicial engagement where courts respond sensitively to social needs, democratic realities, and institutional limitations, rather than adhering rigidly to either judicial restraint or judicial activism.
Madam, ini lecture ka? Bimal kila ringi kata ni make urla dem manggalna.
So if you are not asking questions, can you please mute your mics? Yes, so the responsive judicial review mainly referring the sensitively to the social needs, democratic realities, and institutional limitations, and they are not strictly adhering with the judicial restraint or judicial activism. It means a middle path in between the judicial restraint and the judicial activism. So in that sense, it will not become a threat to the separation of powers, and as well as it will provide or the facilitate to the protection of individual rights as well. When it comes to dialogic model of judicial review, again, as we discussed earlier, now the definition of democracy and also the definition of separation of powers has also been subjected to certain changes and modifications. Under the dialogic model of judicial review, they view court and legislature as partners in constitutional governance rather than adversaries. So together they have to find solutions. Both legislature and also the court, they are part of the constitutional governance process. Instead of asserting judicial supremacy, courts initiate a constitutional dialogue giving reasoned interpretation of rights and constitutional values, while allowing the legislature or executive to respond, amend, or reconsider their policies in light of those interpretations. Court also should not be engaged with strict judicial supremacy and also need to initiate a constitutional dialogue giving reasoned interpretation of rights and constitutional values. So they are suggesting a dialogic model, or it is necessary to create a dialogue with the legislature and also the executive with regard to the amendment, reconsideration, etc. So these are the newly developed two approaches to judicial review. The right-based review can be facilitated through these two models of judicial review. So still these two are at the, it's established, but there's no many researches conducted based on these two. So especially in the context of Sri Lanka, this is a very good area that you can do research based on this. So with that, actually, I can conclude my part. If you have question, again, we are having some time. Any question? If you don't have questions, we can conclude the session.
I have another one question, madam.
Yes.
Yeah, there is a famous saying that justice should not be done, but it should be seems to be done. No,
Yes.
I don't know whether it is correct or wrong.
Yes,
Then,
it's correct. Yes.
yeah. Then can you elaborate on the second part of that saying by applying the judicial review? I mean,
You mean that then the what's the anyway? It's a kind of like the well accepted maxim. It's a maxim.
yeah.
It means say for example, mainly what they are referring, the transparency should be there.
Yeah.
Because the sometimes in some cases the justice has already been done, but then the process, so that cannot be seen. That's what I think you are referring. It means the process should be, this entire process should be transparent. So that is why anyway this when it comes to judicial review, that's why this reasoning is very important. I think many cases we referred about the reasoning. Did you remember this Kumara versus Gunatilaka case? Kumara versus Gunatilaka case. So that's what exactly discussed in this case. Reasons were the part of the rule of law. Anyway, the reasons are the part of judicial review. So then reason should be given. Otherwise, there's no transparency process. It's well-established norm, Dhammika. The reason should be given. If not, that can be challenged. Many cases challenge the same issue, even the Karunaratna versus Unique Gemstone case. I myself discussed two cases as an example for your fiction.
Thank you, madam.
All these principles are attempting to bring this transparency to the justice system. especially this responsive judicial review and also the dialogic model of judicial review. Any other question? So you can ask any question. If not, if you don't have any question, then shall we conclude the session?
Thank you very much, madam, for that insightful session. We truly
Yes, the Sweta, give me 1 minute. One question ask this one student, I think, why an application of writ was sent to SC in Karunadasa case. So again, the same article 126.3 will apply, because if there is prima facie, if there is a violation of fundamental right, that should refer, or the shall, it should refer to the Supreme Court. Okay. I think you are satisfied with the answer, Imasha.
Okay, thank you very much, madam. We truly appreciate your valuable knowledge and time you spent with us today. On behalf of Legal Youth Committee, I would like to thank all participants for joining with us today and make this session successful. So we hope this webinar added value to your academic and professional career. So we look forward to see you again in our upcoming sessions of the Jurists Forum 2025. So have a great evening and thank you all of you once again.